Hi, I'm Shan with the Undercolor of Law take on the U.S. Attorney for D.C. beginning a Investigate the Investigators. Now, does that sound a little bit familiar to us? It should. We'll talk about it more. So the D.C. U.S. Attorney, who is an interim U.S. Attorney, a guy named Ed Martin, who is likely to become the actual U.S. Attorney, he has launched an internal review of the January 6 cases. So first, who is Ed Martin? Well, to start with, let me say something about D.C. attorneys' history of who gets selected. Local ties is actually a big deal for D.C. It's a very unique jurisdiction because the U.S. Attorney's Office prosecutes all the local crime in addition to the traditional white-collar federal crimes. So there's been a big effort to make the U.S. Attorney somebody who has local ties, someone who means something to the community and understands the community. In fact, there was a period where you really had to actually live in D.C., although under Republican administrations, that tends to be rather bent. I know a little something about that because at one point I was one of the candidates for that position, and I actually spent a lot of time gathering community support. Now, Martin is from Missouri. His experience is he advocated for January 6 defendants, and as far as I can tell, he has no criminal prosecution experience and no ties to D.C. So, putting that aside for a moment, which are his qualifications, he is also the guy who sent Trump a congratulatory message on Trump's pardoning of 2 police officers in D.C. who had been convicted of murdering a young man and then covering it up. So that's just a little bit of context for you here. So we'll put up the headline talking about what Martin's doing. And overlooking the question of his qualifications, it's absolutely no surprise that he wants to do this Investigate the Investigators bit. He wants to look at all the January 6 cases that the D.C. U.S. Attorney's Office brought, and he wants to take a look at whether there was something wrong with them. Now, maybe he's just trying to pull sort of a John Durham style Investigate the Investigators, because Durham got a lot of mileage out of that, as we know. He got to travel around the world kissing up to A.G. Barr. Martin gets to kiss up directly to Trump here, and maybe what we really need is a Gangnam style kind of meme here, maybe with cats. I don't know, but we'll see. So what he has said is, in an email, as the Washington Post reports, he's appointed a current chief of the criminal division in D.C. and another chief of another section to lead a, quote, special project. He wants to investigate the office's charging of more than 250 of the Capitol riot defendants because he characterizes this as a great failure of the office, that the office used 18 U.S.C. 1512, and he says that because eventually the Supreme Court ruled that you couldn't use Section 1512 for obstruction of justice if the obstruction was a bunch of people breaking into the Capitol, beating police officers, threatening to hang the vice president. Physically obstructing, according to our Supreme Court, was not obstruction. It was going to be limited to destroying paper trails, so actual evidence, so to speak, tampering. So Martin has ordered folks to deliver all their files, emails, and other information, and he says, be comprehensive and assertive in this, please. This 1512 project is important work. Always question it when your boss tells you how important the work is. Now, the point here is, nothing is wrong with the charging process. Courts all agreed that the use of 18 U.S.C. 1512 was fine until the Supreme Court got a hold of it, but the court got a hold of it on a strictly legal issue, which was, can you obstruct the proceeding by physically interfering with it, rioting, trying to kill people, or only by destroying documents? And SCOTUS said, only by destroying documents. The other stuff doesn't count. Now, I think it's a lousy decision, and was a complicated decision we'll talk about in a second, but it has nothing to do with the integrity or propriety of the prosecutor's charging process, the charging decision. So to illustrate how silly this is, to say there's something wrong with the charging process, let's listen to Professor Jonathan Turley talking about that Supreme Court decision, and we'll play you a clip of it here.
That I was surprised by how heavy the Department of Justice went on obstruction. I analogized it to someone going to Vegas and playing roulette, but only betting red. Well, basically, the court just said, red's not a bet.
So note what he says about it being improperly charged. That's Turley's phrase. No, he's speaking either quite sloppily or maybe he's deliberately trying to make an ideological point to defend Trump. The charging decision, the decision to charge, is not at issue. What the High Court said is that the charges don't legally work when it's about physical attacks or obstruction versus paper evidence. That doesn't say anything about the charging process. I don't know how Professor Turley thinks roulette works, but his comparison makes no sense. All he's saying is, oh, I'm so smart, DOJ should have hedged their bets. You know what that is called in roulette if you bet both black and red? It's called betting against yourself. But I digress. In any event, this may all be a setup that Turley was doing for a long game to stage for the possibility at that time of Trump winning. Listen to the second short clip here.
What a day. I mean, his nominees put the court over the top in delivering the coup de grace on Chevron, and then they just knocked out hundreds of these convictions for January 6th.
Yeah.
These citizens should not have been charged with this crime.
He's also a little bit off about what a day it was for Trump stacking the court, and his stacked court came through for him, because actually in this case that's not quite accurate. Amy Coney Barrett went with the dissent here while Ketanji Brown Jackson went with the majority. Now, Coney Barrett said that the majority was engaged in, quote, textual backflips to find some way, any way, to narrow the reach of subsection C12. That's hardly an example of Trump's hand-picked justice wanting to stack the decks for him. The point being, this was not a slam dunk legal conclusion, nor did it have anything to do with prosecutorial abuses or errors in the decision of what to bring. But that's what Hurley wants to spin it at. In fact, for a very technical reason, Ketanji Brown Jackson went with the majority, but she did feel that you could still bring that charge. She did agree that it had to be limited to paper, but there are other parts of that case which would have involved the paper aspect of it. That's a little bit too much in the weeds. We don't have to go there. The main point is that this was a complex legal decision that appropriately made its way to the U.S. Supreme Court. We can disagree with their decision in it, but again, it's not a slam dunk. Other courts have said it was a fine use of that charge, and therefore it's got nothing to do with whether you need to investigate what went into that charge. So, you know what Martin's going to find when he gathers all these memos and stuff? Absolutely zilch about the legal analysis of the case, because those will be memos about what evidence there is, who the witnesses are, can we prove this beyond a reasonable doubt? It's not going to reveal people going, oh, this is legally pointless. We know we're doing something that's wrong legally, because they weren't doing anything wrong legally, and courts agreed with them until it got to the Supreme Court. Look, frankly, as an alum of this particular office, it's really a disgusting abuse. And while it's easy to second guess those who are still there, who are now having to oversee this investigate the investigators notion, I mean, some have resigned, actually. Some people have resigned since Trump pardoned all the J6ers. I was a supervisor in that office. I've run task forces. I never would have accepted such a task. Every special assignment that I got was one which you could be sure was an assignment that had a mission of good intention, of integrity. What's really going on here is what the current acting Attorney General of the United States said, where he began to do where he fired all these people at Maine Justice Department who were Jack Smith's team, because they didn't trust that these people would be lackeys for Trump. They wouldn't do Trump's bidding. So there was nothing wrong with this process. There was a crime, a blatantly obvious crime, investigation, grand jury, layers and layers of review, and courts that agreed about bringing the case before yet another outlier Supreme Court decision said, oh, you can't use it in this very narrow fashion. That's the kind of nonsense that's continuing to go on, and it's going to do tremendous damage at a place that does a lot of valuable work for the community, of the people of the District of Columbia. So that's it for now. Thanks again for all the replies and comments. Keep them coming, and it really helps us a lot. So I'll talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.